Yeah, got it.
All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. We have one matter scheduled on our docket. It is an arraignment on a bench warrant. People of the State of Michigan versus Brandy K. Bedell. It's file 25-7039FH. Counsel, you want to state your appearances beginning with people, please?
Anthony Juliet on behalf of the people.
Brian Clement, I have Brandy Bedell.
All right, good morning. And Mr. Klain is appearing by Zoom video. Ms. Bedell is appearing by video from the Sheboygan County Jail. Either one of you let me know anytime if you need a breakout room. And Mr. Klain, is it okay if I arraign her on the two other show causes as well at the same time?
Yes, sir.
Okay. So Ms. Bedell, it's alleged that you are in contempt of court by violating your bond conditions. That's in three different documents. Back on June 16th, the court signed an order to show cause for an alleged dilute drug test sample from 610. On 625, the court signed a second order to show cause for a dilute test on 620. And then on 722, the court signed a bench warrant for your arrest for dilute tests on 7/7, 7/10, 7/11, and 7/15. And you were lodged on that warrant yesterday from the courtroom on an unrelated matter. You've got the right to have a hearing on those allegations, where the allegation that you're in contempt of court would need to be proven by beyond a reasonable doubt. You have the right to the assistance of Mr. Klain at any such hearing to present evidence in your own defense and to question any of the witnesses presented against you. If you are found to be in contempt of court, you could be jailed for up to 93 days and or fined up to $7,500. Also, if I believe that you're not following the conditions of your release, I can modify or revoke that release. Do you have any questions for me about your rights or the penalties that you could face, or any need to talk to Mr. Klain about those two issues?
No, Your Honor.
All right, Mr. Klain, do you know how she wishes to plead to that?
Yes, Your Honor. At this point, we're asking the court to plead, enter a plea of not guilty to the allegations. I would also indicate to the court that although I haven't spoken with Ms. Goodrich this week, we were just putting the finishing touches on a plea that would resolve the whole case in total. So I'd ask the court to consider, I believe she's got a status conference coming up that's going to be a plea hearing. I'd ask the court to consider setting the hearing for the same time, I suppose. So maybe we can incorporate all this into the final resolution of the case, at least the pre-plea resolution to the case.
Okay. We'll enter a plea of not guilty as to the contempt. I see that she's scheduled a week from today for an arraignment on both cases that she has, this case and then a separate harboring a felon case. We'll schedule in this file, along with the arraignment, a status conference on the pending contempts for the same time as the arraignment. And Mr. Klain, let Mr. Juliet or Ms. Goodrich know if you'd like that instead to be an evidentiary hearing, and they'll notify any witnesses necessary.
I will.
All right. So as to any release between now and then, Mr. Klain?
Your Honor, I would be, and I understand that a dilute test is a serious allegation. I'd be more concerned if they're a positive test. I understand that a dilute test is treated as a positive test, but I'd ask the court to consider releasing Ms. Bedell. It's only a week until the next hearing, and even though it's just going to be the arraignment, I will tell the court that the work that we've done so far would result in this case, the whole case being resolved, both cases, the harboring or a fugitive and the possession of methamphetamine. So with the posture of the case and the progress that's been made on the case, I'd ask the court to consider releasing her on bond.
Mr. Juliet, people's position.
Your Honor, I would ask that bond continue to be denied at this point. There were the two original show causes that the court signed, all for dilute tests, and now the bench warrant for several dilute tests that suggests a pattern that perhaps she is using. So I would ask that bond be denied.
All right, before the bind over, I see in the court file there was one dilute on June 4th. Then while the arraignment's been pending, we've sent out 2 show causes. While those are pending, I did a warrant for 4 more dilutes. Other test results we've had in June or July are 3 negatives and 2 more dilutes. That means over a 2-month period, she's been tested a lot. I think because the dilutes kept coming back. So the testing folks were trying to figure out what's going on. It's not many times I see 9 dilute tests in that short of a time. That raises serious concerns that she's using and intentionally masking that use, which is even more troubling than if she's just struggling and using and asking for help. So I think until I have a better sense of what's going on, I'm going to revoke Ms. Bedell's bond. And I'll enter an order in both files so that we can be sure that she gets credit. Even though, well, I guess, Mr. Clayton, do you have an objection to that?
No.
I'm going to revoke it in 7038 until further order of the court and see where we're at with maybe any treatment needs or something like that. 7039, I want to make sure she would get any credit.
In People v. Brandy Bedell, the defendant appeared for arraignment on a bench warrant and multiple show cause orders related to diluted drug test results, 9 within 2 months. Her attorney entered a plea of not guilty, noting ongoing discussions toward a global plea agreement that could resolve both her drug possession and harboring of fugitive cases. The defense requested bond reinstatement, but the prosecutor opposed, citing a repeated pattern suggesting possible intentional masking of drug use. The court agreed, finding the situation more troubling than mere relapse, and revoked Bedell's bond in both files pending further review at the next hearing.
She would get any credit in that file. She hasn't, there's no alleged violation in that file, but I can enter an order revoking the bond in that. And if I do a reinstatement, it would of course apply to both.
Right.
Any thoughts about that?
No, that makes the most sense.
May I?
Well, Ms. Bedell, I'm sure that Mr. Clayton doesn't want you to say anything about the situation. I could put you in a breakout room so that you could run it by him and then see if he wants you to share what you were about to share with the court. If you want that, I'd be happy to do that.
That would be great.
Okay, so we're not going to go off the record yet. We're not going to conclude the hearing yet. I'll create a breakout room for Mr. Clayton and Ms. Bedell to speak briefly, and then we'll go from there. Back on the record and recalling the Bedell matter, the breakout room with the LGM should be closing here. All right, Mr. Clayton.
We should be fine for today, sir. We'll see you next week, and hopefully we can get this all put together.
Okay, very good. We'll see you next week, Ms. Bedell.
All right, thanks.
We'll be adjourned.